rise. Third District Court is now in session. Honorable Kylie Stick presiding.
Thank you. Please be seated. Are we on the record, Madam Clerk?
Yes, we are.
Good afternoon. We'll be on the record. I'm Judge Kylie Stick. I'm the District Court Judge assigned to this case. Today we're taking up the case of the State of Idaho versus Andrea Renee Shaw, CR 3826-1685. We have Mr. Duke and Mr. Surchek present this afternoon on behalf of the state. We have Mr. Felicetti present this morning with his client, Ms. Shaw. This is the time set for District Court arraignment on the indictment that was returned in this matter. There are two other matters that we should take up today. We've got the arraignment on the indictment, the motion for grand jury transcript that Ms. Shaw filed, and the motion for bond reduction. We'll start with the arraignment. Mr. Felicetti, have you and your client received a copy of the indictment?
We have.
Ms. Shaw, have you had a chance to review the indictment?
Yes.
Ms. Shaw, you have a right against self-incrimination and to remain silent. You are not required to make any statement that might incriminate yourself. Any statements that you do make can be used against you in later proceedings. Do you understand?
Yes.
And the state has listed your name on the indictment as Andrea Renee Shaw. Is that your true name?
Yes.
And Mr. Felicetti, would you waive formal reading of the indictment on behalf of your client?
Judge, we would. She reads, writes, and understands the English language, and we walk through the indictment.
All right, so we'll just summarize those charges for you. Count 1 of the indictment alleges first-degree murder with respect to DS. Count 2 of the indictment also alleges first-degree murder with respect to the child TS. Do you understand those charges, Ms. Shaw?
Yes.
Counts 1 and 2 both carry with them the same potential penalties. The charge of first-degree murder or felony is punishable by up to life imprisonment or the death penalty. It's punishable by up to a $50,000 fine, or both such fine and imprisonment or a death sentence. It has a mandatory minimum of 10 years in prison, which must be fixed, and a minimum of life in prison. It allows the court to impose up to a $5,000 civil penalty in favor of each victim. The court cannot grant parole, probation, or withheld judgment. If you're convicted, a DNA sample and right home progression will be required. Do you understand those penalties, Ms. Shaw?
Yes.
If you are convicted of both of these offenses, the court can order those penalties to be served consecutively, meaning back to back. Do you understand that as well?
Yes.
Ms. Shaw, today you can plead guilty, not guilty, stand silent, in which case the court will enter a plea of not guilty on your behalf, or you can request some reasonable additional time before entering a plea. Ms. Shaw, how do you wish to plead today?
Judge, we're going to set aside entry and plea until a later time after this one. I would like to get my hands on grand jury transcripts before that time, if possible. I think that's 30 days.
I think 30 days, depending on the number of pages. You have a right to a speedy trial. The state is required to bring you to trial within 6 months from the date you first appear before the district court, which would be today. So your speedy trial date would be January 14th of 2027. Okay, well then I guess it probably makes sense to just get you that entry plea date, and then we can schedule pre-trial and trial at that next hearing. Does that sound good to the state?
It does, Your Honor. Thank you.
How about Tuesday, August 18th?
That works, Judge. 1:30.
Does that work for the state?
It does, Your Honor.
Yeah. Tuesday, August 18th at 1:30 p.m. For entry plea. Good, we can take up the motion for the grand jury transcript.
Your Honor, the state doesn't object to
And you were fine with the proposed order outside?
that.
Actually has a spot for you to sign it, and so why don't I just hand this to the marshal and hand it to you to review?
I will say, Your Honor, I did not see the proposed order before this. There's additional details in here that, well, there are deadlines in here that the state's not going to apply itself to. As far as splitting the costs, the state's okay with that. But the state, also, I guess, we may have to have a hearing on that.
You may have to wait.
Have a hearing on that, because,
Certainly does, yes.
yeah, you're right. I think sort of. We've crossed out paren 2 and paren 3. They're simply put time limits on challenging language in the transcript. I think we've agreed now that the best way moving forward would simply get a copy, and then if we do have issues with the content or the actual transcript, then we can file motions afterwards. Or, follow the procedural mechanisms we need to at that point. And so, so I'm going to go ahead and sign it, but we did make those alterations.
Judge, I would say, I would like a copy of the transcript of the formation of grand jury, and then the colloquy that occurred between the court and the prosecutor to set law.
Okay, yeah.
And I have no objection.
There's a spot for defense counsel as well. And maybe, Mr. Phil said, why don't you cross out those two provisions and initial that, and let's have Mr. Jenkins do that as well.
You want to strike these?
That's what she said.
To order the transcript to be prepared. That will be a sealed copy of the transcript that will be provided to each party and will to be used as set forth by the transcript order. We did have a court reporter present for the grand jury that were here in the courtroom. We can open Madam Clerk to send this order to her as well. Jury selection, proceedings of the grand jury, and the return of the indictment and bond argument. Will not include the deliberations, of course. All right. Anything further on the grand jury transcript issue, counsel?
No, Your Honor, thank you.
From the defense.
Very good, then we can proceed to take up the issue of the motion for bond reduction. Mr. Philisetti had a chance to review the motion that you filed back on July 2nd, the amended motion that you filed yesterday, your exhibits A through D, which I did grant the motion to file under seal. Those did contain personal data identifiers that should have been redacted by your children's names, dates of birth. Those are all subject to redaction under the Idaho Rules of Electronic Filing and Service 15B, and pursuant to ICAR 32, little I3, capital A. To seal those. However, I just want to let counsel know that I want to file ICAR 32 carefully, balance the public's right to know information with the provisions of that rule. So stating that something is confidential or that the public has no interest in it is not one of the factors set forth in ICAR 32. So please be sure to comply with that rule for any future motions. All right, there was also a couple of affidavits that were submitted. I had a chance to review those as well. I did have a chance to review the state's objection that was filed earlier today, I believe it was. So we can proceed. Do you have any additional argument you'd like to present today, Mr. Philisetti?
Just very briefly, and that's it, and just going through the amount of discovery that they've provided. There's a lot of audios and videos as well that I cannot touch. But from it, I glean, the coroner has a different opinion as to the cause of death as what the prosecutor's office thinks. This is certainly a case in search of a crime. is not the client in this case. I'm going to defend this case like she's not guilty because she's not guilty. It's not going to be a typical case. I just asked the court, after reviewing their evidence, I think release on their own recognizance would be even allowable in this case. But I'm not going to ask you to do that. I'm going to ask you to set a $100,000 bond with restrictions, and I think we've outlined everything in there for the court. Thank you.
Thank you, Mr. Pensetti. Any response from the seat?
Thank you, Your Honor. Your Honor, in this case, the defendant is not even entitled to bond. This is a death penalty case, or it's death penalty potential, and as such, the court pretty much has unlimited discretion in how it decides bond. In the Constitution and in the rule, it comments that the court can look at the strength of case. That's why we briefed it the way we did. Just to point out that the details of this case are extraordinarily alarming. The reality is when two kids die at the exact same time in the same house in the same bed, that the state takes an interest in that. And the reason I rehash some of these is because I want to point out that
this hearing may have focused on procedural issues like arraignment, bond, and evidence, but make no mistake, the real courtroom battle is only beginning. With first-degree murder charges, possible capital punishment, and both sides already clashing over the cause of death, every future hearing could reshape this case. What do you think? Should the court consider reducing the bond, or do the allegations make detention the right call?
environmental causes, which is what the coroner was looking at, those were proposed early on. And as part of the investigation, they actually looked to see how hot the room got. It did get extraordinarily hot. The coroner looked at news articles, and based on news articles, thought that it was possible. We relied on the opinions of experts, doctors who take care of kids, and they ruled out heat, both because time of death doesn't work with the heat theory, because in order for heat to be the cause of death, it would have taken longer, and the children were in full rigor when they were discovered at 11:30, and so that takes about 8 to 12 hours, and in order for the room to get hot enough for the twins to experience that heat for long enough, then it would have died later. And the doctor does support the conclusion that suffocation is the cause of death, which we used in the grand jury.